And after having even reviewed all of the defense's assertions as to the defense's argument with respect to errors made by my predecessor judge, I'm going to place on the record that I would not have ruled any differently.
She had read every word, every transcript from a trial she did not preside over, every motion, every ruling, every objection logged by a judge who no longer sat on this case. She had gone through the evidence, physically, item by item. Because the evidence had been locked away in a defendant's trial running in a parallel courtroom until Monday. She had reviewed the pre-sentence investigation report. She had read the defense's written arguments and the state's written responses. She had done all of this before walking into this courtroom. And then, when the defense stood up and asked her to reconsider every key ruling the previous judge had made, the evidentiary decisions, the charge conference, the text messages, the principal jury instructions, all of it, she paused, and she said 8 words that functioned less like a ruling and more like a door swinging shut. I would not have ruled any differently. That was the moment, not the sentence that followed, not the victim's mother's devastation read into the record minutes earlier, not the defense's last-ditch argument citing 8 comparison cases and a statute that might have sent their client home with 5 years of probation. That single sentence, quiet, prepared, surgical, was the moment this case ended. Everything after it was mathematics. But to understand what those 8 words actually meant and why they carried the weight they did, we need to go back to the beginning. Because before this judge ever walked into this courtroom, someone else had been sitting in that chair. And that someone had been removed from the case entirely. Alicia Andrews was facing a murder charge. Second-degree murder, meaning the state alleged she was involved in the killing of Charles Jones, known publicly as the rapper Julio Fulio, as part of what prosecutors described as a coordinated plot involving multiple individuals. 4 co-defendants faced the same case. The difference between Andrews and those co-defendants, as the defense would argue repeatedly, was the nature and degree of her participation. She did not pull the trigger. What she allegedly did, what the jury ultimately found sufficient to convict her, was participate in the events surrounding that killing, travel with the others, monitor movement, remain present and involved throughout the sequence of events that led to Charles Jones being hunted down and shot. Under Florida's principal theory, the legal doctrine that holds you criminally responsible for a crime you helped facilitate even if you weren't the one who committed it directly. The jury found that enough. A jury did not convict her of second-degree murder. They convicted her of manslaughter. That distinction matters enormously, and we will return to it. But before any of that, before the sentencing arguments, before the victim's mother's words, before any of this, a judge had been disqualified. Florida law has a specific rule for exactly this situation. Rule of Judicial Administration 2.330 subsection J. It says that when a judge is removed from a case, disqualified for bias, conflict of interest, or any other legal reason, the successor judge who takes over has discretionary authority to revisit and potentially reverse every ruling the disqualified judge made. The key word is discretionary.
Record, it's the Rule of Judicial Administration 2.330 subsection J, and I think both of you all cited that rule in your motions as well as in the state's response, that it is discretionary, and I'll cite the rule. Subsection J says prior factual or legal rulings by a disqualified judge may be reconsidered and vacated or amended by a successor judge based upon a motion for reconsideration, which must be filed within 30 days of the order of disqualification, unless good cause is shown for a delay in moving for reconsideration or other grounds for reconsideration exist. So that is...
It is not automatic. It is not required. A new judge can look at every decision made by their predecessor and say, I am going to reconsider those. Or they can say, I am not. The defense in this case wanted reconsideration desperately. They had filed a motion specifically targeting the previous judge's rulings on domestic violence evidence, on text messages, on jury instructions, on the charge conference. They believed those rulings had been wrong. They believed a fair review of those decisions would result in a new trial. And with a new judge on the case who had never heard a moment of the original trial, they had reason to hope. That hope arrived in this courtroom on a Tuesday morning in May, and it lasted approximately 6 minutes. The judge opened proceedings by telling both sides exactly what she had done, not what she was about to do, what she had already done. She had read the transcripts. She had reviewed the evidence. She had gone through the defense's motion and the state's response. She had considered each of the predecessor judges' rulings that the defense was challenging, one by one. She was not walking into this hearing cold. She was not going to listen to arguments and then deliberate. The deliberation was finished.
So the first thing that I want to address is, just to put on the record, is I did read all of the transcripts that were provided to me a couple months ago. It took me a while to go through them. I successfully read all the transcripts, and I did an evidence view of the things that were in evidence. There were a lot of things that were missing from evidence because they were in the trial of the co-defendants up until, I think, Monday. My clerk did deliver to me all the items that were marked on the exhibit list that were in possession of the clerk of the court in the co-defendant's case. And I did receive those on Monday, and I did review.
This is worth pausing on because it is not how courtroom proceedings typically feel from the outside. We are conditioned by legal dramas to expect the argument to happen in the room. The lawyer stands up, makes the case, the judge weighs it, and something shifts. Here, the shift had already happened. In private, over weeks, before a single word was spoken in open court. The judge was not gathering information. She was delivering conclusions. Motion to reconsider the predecessor's rulings. Denied across the board. And not just denied, but denied with the additional observation that she would not have ruled any differently herself. Motion for judgment of acquittal. That is the formal request asking a judge to set aside the jury's guilty verdict because the evidence was legally insufficient to support it. Denied. This motion has two forms, one made before the jury deliberates and one made after. She denied both. Motion for new trial. Also denied. Three separate legal mechanisms through which Alicia Andrews might have walked out of this hearing with a path forward. Eliminated in sequence, calmly, with the preparation of someone who had already done the work. The defense's final argument, the one they would need to make under these circumstances, was not about innocence. It was about proportion. Here is where the case gets genuinely interesting from a legal standpoint, and here is the question I want to pose directly when someone is convicted of a lesser charge in a case that began as murder. Should the sentencing reflect the severity of the original act or the severity of what the jury actually found? Think about that for a moment. The jury said not murder, too. But the facts that led to this trial, the planning, the coordination, the following, the hunting of a human being across a geography until he was in the right position to be shot, those facts do not disappear because the jury returned a manslaughter verdict. The question the judge had to answer was, how much does the verdict ceiling actually constrain what she does next? Florida law provides a framework. Sentencing guidelines calculate a score, a numerical total derived from the nature of the offense, prior record, and other statutory factors. That score produces a minimum. In Alicia Andrews' case, the bottom of the sentencing guidelines was 9 years. The defense wanted to go below that minimum. The state wanted to go above it, all the way to 15 years. Going below the minimum requires what is called a downward departure, a formal finding by the judge that specific statutory factors justify a sentence outside the calculated range. The defense cited one in particular, that the defendant was an accomplice, not a principal, and played a relatively minor role in the criminal conduct. They supported this argument with 8 comparison cases. Real Florida cases, real defendants, real sentences. They laid out the scoring sheets, the arrest records, the judgments. People convicted of manslaughter or crimes resulting in death who scored the same number of sentencing points as Alicia Andrews and received 5 years, 7 years, not 15. One defendant had admitted at the scene to the shooting, same score, 7 years. Another had been originally charged with second-degree murder, pled down to manslaughter with 176 total sentencing points, identical to Andrews, and received 5 years. The defense's argument was not that Alicia Andrews was innocent. That ship had sailed. Their argument was that 15 years, the maximum they could ask for, was disproportionate relative to what Florida courts had actually done in comparable cases. And we are at the midpoint of this story. Everything that came before was prologue, because what happens next? The victim's mother's words, the judge's final calculus, the sentence itself, is the part that will tell you something important about how courtrooms actually work and what the law can and cannot do for the people left behind by violence. Before any argument was made about numbers or guidelines or comparison cases, a woman named Sandra May walked into that courtroom and sat in the witness chair. She is Charles Jones' mother. She read from a written statement. She said her son was hunted. She used that word. She said he was followed, tracked, ambushed. She said the trauma of his death follows her every single day. She said Alicia Andrews' family can see her, can talk to her, can watch her grow older. And she said, and this is the line that sits in the room after everything else has faded. She said, I have to go visit my son in a wall at the cemetery. She said no sentence will ever bring Charles back to her, but accountability matters. There is no legal analysis adequate to that statement. There is no counterargument. The defense did not attempt one. You cannot cross-examine grief like that.
The Honorable Judge, my name is Sandra Mays, and I'm the mother of Charles Jones, known to me as Julio Fulio. I stand before this court carrying the pain that no mother should ever have to endure. My son was more than a rapper or a public figure. He was my child. He was deeply loved by his family, his friends, and the people whose lives he touched. Since the day he was taken from us, my life has never been the same. The actions connected to this case did not just take one life. They destroyed an entire family emotionally, mentally, and spiritually. My son was hunted, followed, and ultimately murdered in what authorities describe as a coordinated plot involving multiple individuals. It is extremely painful to hear Alicia Andrews portray herself as someone who didn't know what was going on. While evidence and testimony showed she traveled with the others, tracked my son's movements, and remained involved throughout the events leading to his death. Whether she pulled the trigger or not, my son would still be alive today had people not participated in carrying out this plan. A mother lives with instinct and intuition, and mine tells me that this was not ignorance. This was participation. It was calculated. They planned it. On my way driving here, every second, every minute, every hour, they could have changed their mind. They could have turned around. But yet and still, they carried on the plan to hunt my son down like a deer in the woods, like they were hunting. This was loyalty to violence over humanity. My son was treated like his life did not matter. He was ambushed and robbed of the chance to grow older, become a father one day, continue his career, and simply live. Every birthday, holiday, and family gathering is now filled with grief. I replay the memories of my son constantly. I think about his laugh, his voice, and the moments we will never get back. The trauma from this loss follows me every single day. No sentence will ever bring Charles back to me, but accountability matters. Alicia's family can see her. They can talk to her. She can see her child, but I can't see my child. I have to go to visit him in a wall at the cemetery.
What the law does, what courts are designed to do, is translate that grief into something measurable, into years.
I ask this court to remember that behind every headline is a real family suffering permanent damage. My son's life mattered. He was not disposable. The emotional devastation caused by this murder reaches far beyond the courtroom and will affect my life forever. I respectfully ask the court to impose a sentence that reflects the seriousness of the role Alicia Andrews played in the events that led to my son's death.
Into a number. And the gap between what a number can hold and what a mother is actually carrying when she walks out of that courtroom is one of the permanent, unsolvable problems of the criminal justice system. The defense made their argument. They cited the statute. They cited the 8 cases. They noted that Andrews had no prior criminal record. This was her first offense. They noted that the co-defendants who actually pulled the trigger were facing life sentences, and that the vast difference between their culpability and Andrews was itself an argument for proportionality. They asked the judge to go below the guidelines. They asked for time served with 5 years of probation. They also told the court that Andrews would not be testifying and that her family would not testify either. They explained why. She intended to appeal the conviction. Testifying at sentencing creates a record that can complicate an appeal. It was a legal calculation, not a moral one. The judge acknowledged it without comment. Then she sentenced her, 15 years. Florida State Prison. Not 9, not 7, not 5. The maximum the state had asked for.
All right, so the court, having obviously reviewed the trial transcripts, the court file, all the evidence in this case, the pre-sentence investigation report, The argument of counsel is the judgment sentence in order of this court to adjudicate the defendant guilty, sentence her to 15 years in the Florida State Prison. You have 30 days to appeal the judgment and sentence. If you cannot afford an attorney, one will be appointed to represent you. You all let me know when you're ready on Casal, please. Okay, thank you.
A number above the guidelines minimum, not below it. The downward departure was denied. The comparison cases did not move the needle. The first offense status did not move the needle.
10 years in the Department of Corrections followed by 8 years of probation. He scored exactly the same amount of total sentencing points as Ms. Andrews. And in that instance, he made a statement, a spontaneous statement at the scene to officers that he shot him. I shot him, were his words, right? In a situation like that, that's obviously more egregious than any acts that Ms. Andrews is accused of doing or committing. Going down the line, Francisco Vallejo, state of Florida, that was a 2000 case. In that situation, the victim was shot numerous times outside of a trailer park and was initially, the defendant was initially charged with second-degree murder. He pled down to manslaughter. He received a 5-year sentence in the Department of Corrections. He had the same amount of total sentencing points as Alicia Andrews at 176. There are people who had even more total sentencing points. Michelle Diane Young, that's the third case cited there. That individual had 180.2 total sentencing points, received a 5-year sentence in the Department of Corrections followed by 10 years of probation. And all of these individuals that I list, and I won't go through each one, but it's all attached to the motion to judicial notice. All of their score sheets, all of their arrest affidavits, the judgment and sentences. All of these individuals, none of them got 15-year sentences. The state is asking for the max on someone who's never been convicted of anything before in her life. This is her first offense.
The argument that the co-defendant's far greater culpability should have pulled Andrews' sentence down, it did not move the needle. She had 30 days to appeal. 30 days. Here is what this hearing actually teaches you, not just as a story, but as something you can use. When a judge is replaced mid-case, the new judge is not a reset button. They are not a blank slate summoned to give the defense a second chance at every ruling that went against them. Rule 2.330J exists. Successor judges have the authority to reconsider. But discretionary authority means precisely that. It is at the court's discretion. What the defense in this case learned the hard way is that a successor judge who does their homework, who reads every transcript and reviews every piece of evidence independently, can arrive at the exact same conclusions the first judge did. And when they say so out loud, in those precise terms, I would not have ruled any differently. The motion for reconsideration is not just denied, it is foreclosed. There is no longer an argument to make. If you ever find yourself hiring a lawyer in a serious case, ask them this question if the judge is replaced. What does our legal strategy look like? The answer will tell you a great deal about how well they have mapped the terrain. A good lawyer is not counting on a successor judge to be sympathetic. A good lawyer is building a case that survives any judge. And if you are ever sitting in a courtroom watching a sentencing, notice what the judge does before they speak. Notice how much they have already decided. The arguments you are hearing, the ones that feel like they might still change something, often aren't changing anything at all. Sometimes the door closed weeks ago, in a quiet room over a stack of transcripts on a day when no one was watching.